All right, again, today we are going to cover chapter 2, and we're going to learn how about the legal system, the court system in this country, and how cases go through the laws and other resolutions that you can use to instead of court. But 1 second here, I think I just have to share this again. Okay, here we go. All right, so that looks right. Looks right. All right, so so some of the basic requirements before a case goes through court, that the court it goes through has jurisdiction over the case, right? A lot of the legal terminology comes from Latin. So jurisdiction comes from Latin. Juris means the law, and diction means to speak. So jurisdiction means a court has the right to speak the law in a specific case, to hear the dispute and to come up with a verdict, with an outcome and a decision, and the parties have to follow that decision. It is a legally binding decision. They can't say, oh, I don't like what this court decided, I'm going to try to go to another court and come up with a decision. It doesn't work. There's usually one court that has jurisdiction in most cases, and whatever that court decides, that will be the outcome. So there's different types of jurisdiction. Jurisdiction over subject matter is certain courts hear certain cases. So, for example, we have probate court, which deals with inheritance. We have a bankruptcy court. If you file bankruptcy, you go to bankruptcy court. We have family courts, where if you have a divorce case, you go to family court, right? That is jurisdiction over a subject matter, right? Then we have, it also depends on the sum of controversy. How much are you suing another party for? It comes up in the next slide, but just quickly, if the lawsuit is about over $75,000 or more, it becomes a federal case. That means it's going to be trialed in federal court. We also have, whether the case involves a felony or a misdemeanor. Do you all remember the difference between a felony and misdemeanor? Anybody? Yes.
Misdemeanor is if you committed something like a crime, the highest amount of imprisonment they could get is like a 1 year, or you can get some fees.
Correct.
Versus a felony is something more, a little more severe, and you can get more than 1 year of imprisonment.
Yes, pretty much it's the severity of a crime. A misdemeanor can be punishable for up to 1 year in prison, like you said, and a felony would be over 1 year in prison, right? And then the original and appellate jurisdiction, there are original courts, and then there are appellate courts. So original courts is where you sue somebody and you go to trial, and you come and present your information, and so does the other party, and then the judge finally speaks the verdict and says what the punishment will be, or the remedy. And then let's say one party is not happy with the outcome of the court, they can appeal the case, and that goes to the appellate court. So now when you appeal a case, you don't appeal it to the same court, but to the appellate court. Because if you went to the same court, they're going to say, nah, we made the right decision, it stands. It has to be another court that reviews the case. Now, how did it go through the legal system? Was it done properly? Were there any errors that we need to consider? And they will review it and make a decision. So that's appellate court. And then federal court, jurisdiction of the federal courts is whenever there are federal questions. Which laws were broken. If it's federal law, it goes to federal court, right? Such as antitrust law, fraud, voter fraud, by the way, is a federal court case, right? And they also look at diversity of citizenship. Sometimes you have two parties that disagree on something, so they go to court. One party sues another. Oftentimes, those people reside in different states. So that's diversity of, that's what it means when it's stating diversity of citizenship. They're two from different states. So that can be tried in federal court. And when the amount is also $75,000 or higher. Questions? More about jurisdiction. I got to put on my glasses here. Let's try one thing. So there's exclusive federal jurisdiction where only federal courts can trial the case. So that's federal crimes, antitrust laws, bankruptcies, patents, trademarks, and so forth. Can you think of any other federal crimes? Or federal cases, any federal laws, basically, right? Concurrent jurisdiction is when there's diversity of citizenship and federal cases where you could do either or, right? And exclusive state jurisdiction is when it can only be in the state courts, is matters are not subject to federal courts, divorce or adoption. So because those are governed by state law. If you go through a divorce, the state that you live in, those laws apply, not the state where you got married in. Adoption, family court, basically, right? Standing to sue, what does that mean? What do you think standing to sue means? That you have the right to sue somebody, right? I mean, technically you can try to sue anybody you want, but there has to be something substantive that happened and that has affected you. You have to be an affected party. If you go out and you see two people fight and damage each other's cars with a tire jack or something like that, and you watch it, you can't bring on a lawsuit. You can't sue either party because it wasn't your car. You have no losses.
Let's sue for PTSD.
Yes, that's a little far-fetched, right? Yeah. But of course, people try all kinds of things, as we know, right, to keep our legal court systems occupied. But yes, if it was something super outrageous, maybe that would be possible, but not in the example I mentioned, right? So that's standing to sue. You have to have a stake in the controversy before you can bring on a lawsuit, right? Yes.
Yeah, I just have a question, something similar to this, but kind of a little bit. So I heard that, from a lawyer, when somebody wins the lottery, family asking them for the money is not their biggest problem. The biggest problem could be that there are people that are out there who are waiting, like, sue people like that who won the lottery. So how would they really do that without any clear evidence and just saying that I was, just go on and sue a person?
You can't really sue a stranger just because they won the lottery, right? You might try to cause an accident, go follow them with a car and do something, brake check them or something like that, and then it's hard. It's hard. I haven't heard that people do that. Maybe employers, employees, something like that. I don't know. I mean, I would say there would have to be some kind of a relationship. If somebody wins the lottery that you don't know that person, you have no relation to that person, what kind of lawsuit can you bring upon them?
Right, there has to be something.
You have to have some contact with that person.
Right.
And you have to have suffered some damages from that person's actions. Whether that's emotional, maybe you can start dating that person and then they say they inflicted emotional damage on you or something like that. I don't know, but it's kind of far-fetched. Maybe a relative could do that. Maybe a divorce. It's like, oh, they won the lottery. Now this is my time to divorce this person, But other than that, I can't imagine anything else that people can just say, I'm going to sue them because they have a lot of money now. Yeah. But what's interesting is sometimes when you have some losses due to somebody did something that works for a company, caused you damages, right? You have the option of suing the company because the company is kind of responsible, and you're more likely to sue the company because they have more money than the individual employee. But again, that's not related to the lottery case. Yeah. But good question, yeah. State and federal court systems. Federal courts are not superior to state courts. They're not the Supreme Court. It's not where it gets escalated and finally it's just another court system. Just like a family court is not superior to bankruptcy court or anything like that. They're not related like that. Okay? The only ones that can overturn decisions are appellate courts. If the party appeals the verdict of the court, then they go to appellate court, and there they can reverse the decision of the previous court. So following a state court case. So first you have a pleading. So a plaintiff brings on a complaint. Let's come up with something. Somebody sues something for what? Let's work this through. Like a business case or something like that. Can somebody make up a scenario? Yes.
Customer came in, they slept, and then they fell out.
Because there was some
Water.
uncleaned area in the hallway in this grocery store, a customer walks in, that area hasn't been wiped in hours and it's olive oil spilled and somebody doesn't see it, falls and breaks his leg. Let's say he's shopping for groceries, pushing the cart, slips, breaks a leg. So sues the grocery store now. So that's the complaint. Okay, the facts. What are the facts? I went to the store, to this particular store owned by this corporation on this date, at this time. I walked through there and minding my own business, looking at the olive oil in the olive aisle. As I pushed, there was some slippery substance on the floor, and I slipped and I broke my leg as a consequence of them not cleaning up the spill. Investigations have shown that the spill has been there for hours, that nobody cleaned it up, that somebody even reported it at the register and they didn't bother to clean it up. So those are the cases. That's kind of a brief summary, right? Then you have statement of remedy. What am I seeking? What do you think, what dollar amount you could ask for if you broke your leg? I don't really know either, but let's just make up an amount. You broke your leg, were in a cast for 6 weeks, then in a boot for another 3 weeks. You couldn't do your favorite sport for 2 months. Then you have to have physical therapy. You have some co-payments from your insurance. Yes. Yeah, let's say you were out of work for 2 months also, because your job is to snowboard. Yes. The medical bills, loss of wages, you could add pain and suffering, loss of enjoyment of life. I lose enjoyment of life if I have a broken leg. I can't do anything I want that I was able to do before I had a broken leg, right? So what do we say? What amount are we suing for? 50,000? I don't know. I'm just making it up. I don't know what's reasonable. Let's just say, okay, so I'm looking for a remedy of $50,000 to make up for all that, right? So then there is a service of process. What does that mean, service of process? Or maybe what sounds more familiar is you have to serve papers. Yes. The what? Oh, the one, if we go before to the remedy. The 50,000, everything. Loss of wages. Well, it's probably would be more. It could compensation for your wages, for your medical bills, your pain and suffering, enjoyment of life. I'm lumped it all together into 50,000. Yeah. I'm just making up a number. Maybe it's not reasonable. I don't know. Maybe it would be more. I have no idea. Yeah. No, luckily I never broke my leg in a grocery store like that. Right. Yeah. I never had to do that, but serving somebody papers, court papers, what does that mean? And why do we have to do that? Yes. So they're notified. There has to be notification that they're being sued. Right? If somebody sues you, you have to know about it so you can show up to court and defend yourself. Because if you don't show up and keep missing to show up, it might just be automatic judgment against you. So somebody has to, not the plaintiff not. It has to be a third party. It cannot be the plaintiff. Somebody has to serve the paper to the defendant, letting them in person, letting them know that they are being sued and giving them the papers with the lawsuit on it, right? And then the defendant answers. The defendant could say, grocery store, who wants to play the grocery store? What are you gonna say? Defend yourself. Yes, Justin.
We're, and we're going to get a sign, a wet floor sign when you haven't slid.
Yeah, we were just about to go. We actually didn't wait 2 hours. Well, maybe there was proof that there was, sorry, didn't go. As a defense.
The water that was there was from the shopper's, water bottle, like it wasn't stolen water there.
Oh, it was, the shopper must have spilled the olive, we're talking olive oil, right? Water is not as slippery as olive oil, right? No, there was no evidence of that.
You can't say like, the sign thing, because you should have someone there to make sure no one slips before you get the sign. So, yeah, no.
So somebody should wait there maybe, but maybe even that, I mean, you could say, well, similar what you said, there was a sign, but the customer didn't see the sign. We had to put a sign before we could get somebody to clean it up.
Buy.
Yeah, that's right. Usually they have camera footage, right?
Shoot them over, direct attention over to shoot them.
Either that, or maybe they were just wearing real high heels that they couldn't walk in. And, they just fell because of the heels, but there's evidence of the olive oil under the shoe and on the clothes and everything, so, they can say it, but that wouldn't be an excuse. That wouldn't be an excuse, yeah. They can say, yeah, we screwed up, sorry. We screwed up, but we're only gonna, we take some responsibility, but we also had a sign there, so, well, when they have a sign there, that's probably usually enough, but we were about to put something up there
But if there was already a report to the cashier and we said it was an hour ago.
yeah, it's already too late, right? Yeah, an hour is not reasonable, right? Yeah, we could say maybe it wasn't an hour, maybe it was just a matter of minutes, like you were saying. We were just about to do it, but we didn't. Yeah, but anyway, they have to provide an answer. They could also say, yeah, we screwed up. We don't want to deal with loss. Let's just settle this case. We're willing to settle for $50,000. The plaintiff can take it or leave it. So it could be something like that, right? But anyway, all of this happens before it goes to and then, if there's still a conflict, if they can't decide based on this, then the trial will start, right? So, and then it has to go through the court. So there can be a jury trial or a bench trial. A jury trial when you have 4 people who decide what's going to happen or who come up with a guilty or not guilty verdict, right? A judge trial is when the judge decides the verdict. Who do you think decides whether it's going to be jury or judge trial? Who is it up to?
I believe it's the defendant.
It's the defendant, yes. The defendant can choose whether they want a judge or jury trial. Most of the cases are jury trials because if you think from a defendant's perspective, you're innocent until proven guilty here in our legal system. It's more difficult to convince 12 people that you're guilty. Right? The only time sometimes when you might want a judge trial is when there was something done wrong procedurally. Let's say it's a criminal case and something procedurally was done wrong, the way evidence was collected and the way that you weren't aware of your rights when you were arrested and all that stuff. If it's based on that, if the attorney says, I'm going to try to get this case dismissed based on that, the attorney will probably ask for a judge trial because the judge is more aware of the procedures and less affected by all the other circumstances, right? But other than that, most of the time it would be, I would probably pick a jury trial if I was, again, it depends on the nature of the case, right? If it's highly emotional, maybe you still want a judge trial now, right? The 7th Amendment guarantees the right to jury trial in federal cases if the amount is more than $20, which most likely it is, right? All right, enforcing the judgment, let's say, yes, the judgment was in favor of the plaintiff and granted the $50,000. That's the verdict. Yes, this grocery store has to pay this person $50,000 to compensate them for damages. That doesn't mean they're just going to write the check right then and there. Collecting the money is another issue. A lot of judgments are not collected, unfortunately. And then you have to go take steps. And there are actually collection agencies that go after collecting judgments and things like that, right? You can hire collection agencies for that as well. It's difficult sometimes to collect. The only things that are easier to collect by garnishing wages is tax evasion. And I think when you have to pay child support and alimony, in those cases, they can garnish your wages. But other than that, it would be really hard to touch your wages. I think would be a long shot. Yeah. Any questions? Yes.
So like, yeah, what if, the case you're saying, like, somebody can't touch your wages, but what if you just don't earn enough and like, you have like, let's say like a $2 million lawsuit, plus you're studying dentistry, for example, and you pay double for your degree.
You don't have money.
Yeah, so you're just bankrupt. Like,
It's hard to collect. It is hard to collect, right? This is why businesses sometimes, even if it's a small business, they create a corporation, or at the bare minimum, an LLC, limited liability corporation. We'll talk about that in chapter 19, by the way, later on at the end of the semester. But where you run a business, but the business is looked at as a separate entity than you personally, so they can't touch your personal assets, right? And because now you're a company and the person is different, even though you're the owner of the company, right? So limited liability companies, means they have limited liability. Yes, what's up?
Yeah, so let's say, in business, limited liability company, does, like a late payment on a credit card or something like that, that could affect, I know that it could affect a personal credit score.
It depends how you applied for credit. So if you applied for credit and used your personal credit as guarantee, then yes, it affects your personal credit. But if the company already has established credit itself and it applies for a loan for a company credit card or something like that, without your personal credit, then they can't touch your personal credit. But most companies, when they start, they're like a newborn baby, a new company, right? They're not going to have any credit history. So no bank is going to give them credit without some kind of personal guarantee. That's why a lot of times you're still personally liable for the loan. Yeah. Anyway, yes, one more and then we'll continue.
let's say I have a business, right? And as I am getting sued, what I decide to do, so I'm notified, what I decide to do right then and there is I have a lot of money in my business. It's a limited liability company. That's my own company. Let's say I own 100% of the shares. I give out all the money that's there as dividend to myself, and then keep the business as it is, or like maybe even lower the minimum amount of where the business must have to keep operating. And then let's say look out, seek out for loans and stuff like that. So if I kind of do that, can they come after my dividends, or it's just gone?
But it's gone. It's gone.
It's gone.
It's
I
gone.
can take out
Yeah.
money.
You could, yeah. And again, it's sometimes difficult to collect those judgments, right? Yeah. Yeah, unfortunately, yeah. There are always kind of some kind of ways, but yeah, what you cannot do is, after the fact, after an incident happened, and you're saying, oh, I'm going to make this into a limited liability company real quick because they're suing me. It's at the time it happened, right? Yeah. So, but yeah, there are all kinds of things you can move money away so they can't touch it and things like that. Yeah. All right. Alternative dispute resolutions is another topic. This is when, the legal cases take forever, sometimes years before there's a final verdict, right? And they're also very costly. You have to pay attorneys, and attorneys are very expensive, $400 plus per hour, right? So it's sometimes in both parties' advantage to do some kind of alternative resolution to solve the case rather than going through court. So there are different things. So there are, let me see what I have here on this side. Unless it's court ordered, sometimes the court will order mediation or something. There's no record, which is an important factor in commercial litigation due to trade secrets. With trade secrets, sometimes the court will order it, right? But the most common alternative dispute resolution tools are negotiation, mediation, and arbitration. And I'll talk about each one of them here now. So negotiation is a formal discussion of the parties, sometimes without attorneys, where differences are aired out with the goal of coming to a meeting of the minds to a resolution, right? We're gonna sit down. I'm the one who's like broke, the grocery store owner, and I sit down and we say, okay, and the grocery store owner, she might admit, yes, we screwed up, and I say, yes, and I had all this trouble I had to go through, and you know, we kind of agree on a dollar amount to settle it. Maybe we say 40,000, and she says, I'll write you a check for 40,000 right now, and you know, we can settle that way, and I can accept it or deny it. We can agree or not agree. If we don't agree, we can still go to court, right? So the next one is mediation. It's unless court ordered, it's usually voluntary, right? You say, okay, we'll go to a mediator. Sometimes the courts might even suggest that, or if you bring on a complaint against an employer for doing something, you know, you go to the, I think EED or something like that, or EEOC, and you bring on a complaint, and they say, well, you know, we suggest you should do mediation first, right? So now you have a third-party mediator that sits with both parties and kind of tries to get you to agree, right? Come up with a win-win resolution, right? But let's say the mediator eventually suggests $30,000 as a remedy to settle the case, and the injured party says, no, that's not near enough. I want 50,000, end of story. And the grocery store owner says, no, that's too much. I don't agree with that. You can still go to court. It's non-binding. So negotiation and arbitration decisions are non-binding. Non-binding means they don't have to accept the outcome. Okay? But then there's arbitration. Arbitration is settling of a dispute by submitting it to a disinterested third party other than court who renders a decision, an arbitrator. There are lots of arbitration organizations, right? Arbitrators have to be neutral. They can't favor one party over the other, right? They cannot violate public policy. They can't come up with a verdict that violates public policy. It can't be illegal, right? And arbitrators cannot exceed their power. They usually have to be part of the American Arbitration Association certified arbitrators, right? They're paid by the company, right? Like if I go to and I'll explain you under what circumstances you have to go to an arbitrator, which is basically an arbitration clause. A lot of business is done through contracts, written contracts, right? And very often written contracts have something called arbitration clause on them. An arbitration clause is when the contract states, if there is ever a dispute between us, we agree to give up our right to take them to court. We agree that we're going to solve it through this arbitration company. And now you as a customer have given up your right to sue them, right? So a lot of contracts will have that. What do you think is one of the, and oh, by the way, arbitration verdicts are, they have to be followed. They're binding, right? They're not like mediation and negotiation. You can still say, oh, no, I don't like this. I'm still going to take them to court. Arbitration decisions are binding for both parties, right? And very often the remedy is not as high as you could have gotten in a court a lot of times. But what do you think could be advantages of an arbitration agreement in a contract?
Low cost.
Low cost, yeah, it's very low cost. If you're going to business with a company and they have an arbitration agreement, they usually pay the arbitrator. They hire the arbitrator. They already have a contract with the arbitrator, right? And it's faster. And it doesn't tear out legal system. You don't have to hire expensive lawyers, right? Yes.
What if somebody doesn't want to listen to the arbitration?
Oh, then you can go to court and then, you know, what, remember we talked about, the pleadings, the defendant's answer. When the defendant answers, the defendant can say, here's the arbitration agreement. They agreed not to go to court. And then the court will say, okay, you have to go to through arbitration. You agreed to that. Yeah, so arbitration agreement should be in writing, right? For that reason. Disadvantages of arbitration agreements.
The decision's final.
Yeah, the decision is final. You can't take them to court anymore, right? And some people argue it could be biased towards the company because the company pays them. The company is literally a customer of the arbitration organization, right? Yeah. So here is a example. Buckeye check cashing versus Cardenia. So in this case, the contract the way I remember it, the contract has I don't remember the details of the contract, what was in question, but the reason why it couldn't be enforced was because the contract was illegal. An illegal contract is not an enforceable contract. As a matter of fact, our courts, in their eyes, there's no contract, right? So this contract had illegal usury, means illegal interest rate, right? There's maximum interest rate, somebody can charge somebody else for a loan. Because the contract was illegal, the arbitration agreement was void as well. When a contract gets voided or technically doesn't exist, then they can't enforce the arbitration agreement either. Any questions? So we do have, eventually we're going to have homework about contracts, and you're going to have to look at one of your own contracts and look at one of the questions is, does your contract have an arbitration agreement? Yeah. So it's a really good assignment. Anyway, I'm going to stop the recording and then we're going to do a discussion. And this.